Hello everyone. In this presentation, the rules regarding the relevancy of statements made by persons who cannot be called as witnesses under sections 32 and 33 are explained. Section 32 and 33 deal with relevancy of statements made by persons who cannot be called as witnesses. Section 60 of the Evidence Act states that oral evidence must in all cases be direct and hearsay evidence is no evidence. Section 32 is an exception to the rule contained in Section 60. Now, who are the persons who cannot be called as witnesses? The class of persons who cannot be called as witnesses under Section 32 and their statements are allowed to be proved in their absence are persons who are dead, persons who cannot be found, persons who have become incapable of giving evidence, and persons whose attendance cannot be procured without an amount of delay or expense. So far as persons who are dead are concerned, in order to make the statements made by persons prior to their death admissible under Section 32, it is necessary that the fact of death of the person must be proved, unless the fact of death can be presumed under Section 108 of the Evidence Act. According to Section 108, where a person is not heard of for a period of 7 years by those who would naturally hear of him had he been alive, the presumption is that he is dead. Regarding persons who cannot be found, before a statement of such a person is sought to be proved under Section 32 on the ground that the person cannot be found, it must be proved to the satisfaction of the court that all effort has been made to locate the witness, but the efforts failed. Regarding persons who have become incapable of giving evidence, their attendance can be waived and their statements can be allowed to be proved on the ground that they have become incapable of giving evidence on account of mental derailment or serious illness. However, temporary illness or mere confinement without illness do not amount to incapacity. So far as witnesses whose attendance cannot be procured without an amount of delay or expense, their attendance can be dispensed with and their statements can be allowed to be proved in their absence by showing that their attendance cannot be procured without an amount of delay or expense, which under the circumstances of the case appears to the court to be unreasonable. According to various clauses under Section 32, the statements made by persons who cannot be called as witnesses are admissible when it relates to the cause of death, when the statement is made in ordinary course of business, or when the statement is against the interest of the maker, or where the statement gives opinion as to the public right or custom or matters of general interest, or when the statement relates to the existence of relationship, or when the statement relates to the existence of relationship made in will or deed relating to family affairs, or when the statement contained in the document relates to transaction mentioned in Section 13, Clause A, and when the statement is made by several persons and expresses feelings relevant with the matter in question. Now coming to the first clause of Section 32. When a statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in cases in which the cause of that person's death comes into question, such statements are relevant whether the person who made them was or was not at the time when the statements were made under expectation of death, and whatever may be the nature of proceedings in which the cause of his death comes into question. Now, what is a dying declaration? A dying declaration is a declaration made by a person as to the cause of his death or as to any of the circumstances which resulted in his death. Why is a dying declaration admissible? Dying declaration is admissible for two reasons. One, the necessity. The victim being the sole eyewitness of the crime that has been committed upon him, excluding his witness would defeat the ends of justice. Second, it is a declaration made by a person under the expectation of death and presumed to be true. it is said that truth sits on the lips of a person who is about to die. The presumption is that when a person is conscious of his impending death, in such cases, he would not lie because he has to face his Maker, the Almighty. For the admissibility of a dying declaration, the following conditions have to be satisfied. The person who made the declaration must be dead. If the person is able to survive after making a dying declaration, then such a declaration will not be admissible under section 32(1) as a dying declaration, although it may be admissible as corroborative evidence under section 157 of the Act. The second condition is that the injuries must have caused the death. If the death is not caused due to the injuries which are inflicted on him, but on account of some other reason, the dying declaration would not be admissible. The declaration must be as to the cause of death or as to any circumstances which resulted in the death. If any declaration pertains to the cause of death of the declarant and also as to the circumstances that caused the death, it can be proved under section 32(1) as a dying declaration. Evidence cannot be given of circumstances unless they are proximately connected with the actual occurrence of the events. The cause of death of the declarant must be in question. A dying declaration is admissible in evidence only when the cause of death of the person making the declaration is in issue, but not the cause of death of some other person. Suppose A and B are assaulted by C. A before death makes a declaration that C attacked B and stabbed him, and B died. The dying declaration made by A as to the cause of death of B cannot be proved. It must be as to the cause of his own death. The dying declaration must be complete in order to be admissible in evidence under section 32(1). Where the declarant collapses even before completing the declaration, then such incomplete declaration cannot be accepted in evidence. But where the incomplete dying declaration unmistakably points out to the guilt of the accused, there is no harm in relying on such incomplete declaration. Before a dying declaration is sought to be proved under section 32(1), it has to be shown that the declarant was in a fit state of mind to make the dying declaration, that the declarant was conscious of his surroundings and of the person who attacked him. Whenever a magistrate is required to record a dying declaration, he puts some preliminary questions to the person in order to ensure himself that the person is conscious of the surroundings and is in a good state of mind to make the declaration. A dying declaration cannot be rejected merely because it was certified by a duty doctor, but not by the doctor who treated the patient, that the patient was in a fit condition to make a declaration, as it is sufficient so long as the person recording dying declaration was satisfied that the declarant is mentally in fit condition to make the dying declaration. The person who is making a dying declaration must be competent. Under English law, a dying declaration made by an infant is not admissible. But in India, there is no such bar, but the competency of the minor has to be determined in terms of Section 118 of the Evidence Act. Now, what is the evidentiary value of a dying declaration? No rule prohibits the court from taking a dying declaration into consideration for the purpose of sustaining any conviction in the absence of any corroborative evidence. But the credibility of the dying declaration would be strengthened by the following considerations. The dying declaration must have been recorded by a competent magistrate. Though a dying declaration can be made to anyone, if it is made to a magistrate and is recorded by him, it will have a greater evidentiary value. Where a judicial magistrate was shown to be unavailable, the dying declaration recorded by the doctor in the absence of any extraneous pressure can be relied upon for sustaining the conviction. A dying declaration recorded by the police officer, although does not stand self-condemned, but the court must look at it with suspicion, particularly when he did not call for the services of a doctor or a magistrate to record it while he had an opportunity to do so. where an investigation officer has recorded the statement of an injured person in a hospital as FIR. The FIR so recorded can serve as dying declaration if later the person succumbs to the injuries. The dying declaration must have been recorded in the exact words in which it is made. As far as possible, the dying declaration should be recorded in the exact words in which it was spoken by the declarant. Where it is recorded in the language of the declarant, it acquires additional strength and reliability. Dying declaration has to be made soon after the alleged incident so that it may not be colored by impressions received from third persons. If there is an interval or there is a time gap, there is a possibility of the dying declaration being tampered on account of the impressions gathered from other persons. Incident must have occurred in a lighted place. This is necessary in order to give sufficient opportunity to the deceased to identify his assailant. Supposing a person is attacked in pitch darkness, he will not be able to see the assailant and hence cannot identify him. In such cases, the dying declaration cannot be relied upon. Where successive declarations are made, all must be identical. They have to be consistent as to the identity of the circumstances as well as the identity of the assailant. Supposing a person attacked makes a declaration to his relatives. When the police arrives, he makes the same statement again, and when the magistrate arrives, he makes to him the same statement. Such a statement, which is identical as to the identity of the circumstances as well as the identity of the assailants, is admissible in evidence. Where there are discrepancies and variations in the declarations recorded by the magistrate and the police officer with regard to the number of persons alleged to have assaulted, and also evidence showing that the deceased might have been tutored or his faculties were impaired, reliance cannot be placed on the dying declaration to sustain the conviction. Where the declaration is made under suspicious circumstances, creating a doubt as to its genuineness, such evidence of dying declaration would not be sufficient to maintain conviction. Where a portion of the dying declaration is found to be false, the court can reject that portion if it can be separated and rely upon the remaining declaration, provided the portion which is false is not likely to destroy the truth contained in the dying declaration. A dying declaration may be made expressly by means of letters or by means of words spoken. No specific form is prescribed for making a dying declaration. It can also be made through signs and gestures, and these signs and gestures made by a deceased are regarded as verbal statements within the meaning of section 32, where the victim's throat was slit by the accused, because of which she could not speak but made signs and gestures and informed as to who the culprit was as responses to the questions put by the police officer and the magistrate. The court regarded it as a dying declaration, taking the questions put to the deceased together with the signs and gestures made by her in response to those questions as verbal statements. A dying declaration, as far as possible, must be recorded in the question and answer form. However, the fact that a dying declaration was not recorded in the form of question and answers cannot be the sole ground for rendering the dying declaration so recorded inadmissible. If the statement of the victim is not recorded in question answer form and in the language of the victim, it will not materially affect the prosecution case. But non-examination of the victim by the doctor before recording the dying declaration and absence of a certificate by the doctor that the patient was fit to give the statement is an illegality that goes to the root of the matter and which cannot be condoned as a procedural lapse. How are the rules pertaining to dying declaration under English law different from those under Indian law? Under English law, a dying declaration is provable only in criminal cases and not in civil cases. Under Indian law, Dying declaration can be proved both in civil as well as criminal cases. Under English law, the dying declaration must have been made by a person who is sure and confident of his death. But under Indian law, it is immaterial whether the declaration is made under expectation of death or not. Under English law, a person making a dying declaration must be competent, that is, have the capacity to make a dying declaration. But under Indian law, every person is supposed to be competent to make a dying declaration, whether he is a person of majority or not. These are the various rules pertaining to dying declaration as provided by Clause 1 of Section 32. Thank you.